extension within which we should comply with IPO. But when we received the order of the ERC May of 2021 and giving us only 6 months to comply with the requirement of Section 8 of RA 9511, at that time, Mr. Chairman, it was already the height of the pandemic. Investor roadshows, cornerstone meetings, as advised by our financial advisors, would be very difficult because of travel restrictions, work from home arrangements. So the advice then was for us to resort to the second mode of compliance. And that's what we did. There is SGP. It is a publicly listed requirement. It owns indirectly 30% of NGCP. Actually 60% because Mr. Henry C. and Robert Cuyuto jointly own 60% of NGCP. And under Section 8 of RA 9511, that is full compliance with the public listing requirement.
Mr. Chair, thank you, Attorney Sagayo po, no? I could see that there's a proviso that the listing in the PSE of any company which directly or indirectly owns or controls at least 30% of the outstanding shares of stock of the grantee shall be considered full compliance with this listing requirement. But there's a following in relation to the ERC's ability to extend po, no? It says, in case compliance with this requirement is not reached, the ERC may, upon application of the grantee, as you very well did, and after notice and hearing, allow such reasonable extension of the period within which the grantee should list its shares of stock. So the extension was referring to IPO po. The order of the ERC was referring to an IPO. I don't think, for me personally, I don't know, but for the consideration of this committee, the extension is very clear. It's only referring to IPO. The second mode, if you opted for it within the 10 years, all fine and dandy. But the extension and the order of the ERC was very clear. How do we now reconcile this po?
Yeah, Mr. Chairman, that's why after we received the order of the ERC denying our motion for reconsideration, we filed a motion for clarification. In the motion for clarification, we clearly stated and we informed the ERC of the two modes by which we can comply with the provisions of Section 5 of RA 9511. And we clearly specified there the backdoor listing mentioned in Section 5. And the ERC came up with an order clarifying that since the law allows you backdoor listing, you can opt or you can choose this mode by which you can comply with the requirement of your franchise on public dispersal of ownership. Thank you, Mr. Chairman. There was a ruling of the ERC itself. That's what we did.
I just would like to ask, when was this? Can you give me the date? When was this ruling of the ERC?
The ERC ruling based on Section 3. It was August 20, 2021, Mr. Chairman.
2021. They ruled that, no? May I ask, when did you take over? 2009?
09.
09.
Yes, Mr. Chairman.
The Section 8 talks about a 10-year from commencement of its operation. Are you still compliant?
We believe we are compliant, Mr. Chairman,
Even though
considering
it's over the 10 years.
Considering that it was the ERC that granted us the extension, and under our franchise, it is the ERC that can give us that extension. We believe we are compliant. And in fact, Mr. Chairman, the ERC came up with its order on 14 May of 2021, confirming that we have complied with the provisions of Section 5, RA 9511 on public dispersal of ownership. Transco was furnished a copy of that decision. PSAM was furnished a copy of that decision. They never appealed. They never questioned the decision. I believe, Mr. Chairman, that under the doctrine of immutability of judgment, a judgment that has attained finality can never be altered, can never be questioned, much more, it can never be revoked.
Mr.
Thank
Chair?
you, Mr. Chairman.
Thank you very much.
Thank you very much, Attorney Sagayo. But unfortunately, I think this is where we have to disagree. Mr. Chair, I believe that nowhere does it say that compliance will be determined by the ERC. It only mentioned that the ERC will extend. And I think the determination of compliance, as in multiple cases that we've handled here in the committee, falls with us in Congress. And that's why precisely I'm bringing it up now. For this representational law, I don't know if the rest of the committee would agree. I could see a violation here po, at least initially, from my understanding. Kasi nga po, very clear po dito. All that ERC is empowered to do is to, upon application of the grantee and after notice and hearing, allow such reasonable extension. They do not determine po compliance. So I'm not sure about the validity of that motion for clarification po, no? Especially na that was a hard left turn from the direct order to actually enlist in the IPO. So I think that's something that we have to consider moving forward. And even further than that, even further beyond the legalese, assuming, you know, that colorably it was applied with, I don't think the intention of the law was complied with. It was not a... Mr. Chair, what was the ownership of NGCP prior to the share swap agreement?
NGCP prior to the share swap agreement, 40% is owned by SGCC, 30% is owned by Monte Oro, Grid Resources Corporation, and 30% is owned by Kalakahay Power Corporation.
And Monte Oro, Grid Resources Corporation, and Kalakahay Power Corporation, they are juridical persons po, no? And they're owned by who po? Whom?
Monte Oro. One Taipan Holdings Corporation owns Monte Oro Grid Resources Corporation. Pacifica 21 Holdings Incorporated owns 100% Kalakahay Power Corporation.
These are wholly owned subsidiaries po.
Yes, Mr. Chairman. Monte Oro
So-
and Kalakahay Power are 100% subsidiaries of One Taipan Holdings Inc. and Pacifica 21 Holdings Incorporated.
And who owned One Taipan Holdings Inc. and Pacifica 21 Holdings Inc.?
Henry C. Jr., Mr. Chairman.
And the Pacifica 21?
Pacifica 21, Robert Cuyuto Jr. and Alameda Energy Incorporated.
Alameda. And who owns Alameda Energy?
Mr. Almeda should be in a better position. Can we
Namesake. So pagmamayari po nila.
can we defer? Can we have that during the next session? I think.
Okay. Sige po. So it's a tripartite. You have 100% ownership by Mr. Henry C. You have 60% on the other side, 60% ownership by Robert Cuito, 68%, and then the rest by Mr. Almeda. So 60% of NGCP was owned by 3 people before the share swap.
Correct.
And supposedly, Section 8 is dispersal of ownership to make it public.
Correct.
What was the ownership of beneficial owners ng NGCP after the share swap?
After the share swap, Mr. Chairman, we have here SGP.
Is it correct, Mr. Chair? SGP was owned 49.93% by Henry C. Jr. and 49.81% by Robert Coyuto Jr.
No, prior.
Right after
No.
the share swap.
Right, that's correct. Yes, after the share swap. Yes, Mr.
So
Chairman.
in your supposed compliance with public ownership, it maintained the ownership of these 2 people.
Yes, Mr. Chairman, if I may, after the share swap, there was a follow-on offering. There was a follow-on offering. Magkano yung follow-on offering natin? We issued shares. Yes, additional 22.12% to be issued to the public. And this was after the follow-on offering, Mr. Chairman. 22.12 of SGP, 22.12% of SGP is now owned by the public.
And this is the SGP is owned by the public 20%. And
That's
SGP
correct.
owns how much of NGCP?
Effectively, it's 60%. SGP owns 67% One Taipan, 100% Monte Oro, then 30 plus 1 of NGCP. Yeah.
So
Okay. Yeah. Okay.
20% of 60%, I apologize, I'm bad at math. Magkano po yan?
Yes. Total, Mr. Chairman, total of SGP ownership in NGCP is 45.73%.
How is that, sir? I apologize. I thought it's 20%